October 2nd.
October 2nd at 9 a.m. will be the jury trial unless something comes up. That looks like a good date, so we'll keep you posted. Does that look like a good date on your calendar, counsel?
It does, Your Honor. Thank you.
All right, so sir, you will need to prepare with your attorney for the jury trial. You have a few months to do that, so if there's anything special that you all need, he'll let us know, and we'll get that evidence for you, or the witnesses or whatever. So you need to continue working with him, do you understand?
Yes, Your Honor.
All right, anything else we need to address today?
Not from the people.
I have a motion to modify, is that modify bond? I do have a bond report.
Thank you, Your Honor, as do we.
What would you like me to know, counsel?
Thank you very much, Your Honor. To be as succinct as I can be, the situation was that at the time my client was arraigned, the arraigning magistrate had before her, of course, a copy of the complaint, and I believe a copy of his criminal record and various information such that she took it upon herself to issue a $200,000 cash or surety bond based on those factors. We appear before the court today because we believe that those circumstances have changed. They have changed rather significantly in that the prosecutor's office is in receipt of an email from the complaining witness in this case, and I don't have it in front of me, but essentially recanting what she had indicated to the authorities on the date of this episode. That being the case, it strikes me that it would be a much steeper hill to climb for the prosecutor to show guilt beyond a reasonable doubt. And it is that concern that I have that would cause me to respectfully move the court to amend the bond from $200,000 cash surety to $50,000 cash surety. And in light of the fact that our trial date isn't until October, I would not want the bond at $200,000 continued and be viewed as punitive. Thank you.
Have you received a letter that recants the events?
Your Honor, the email was sent to Mr. Buxton and he did forward it on to me, so I have had a chance to review it. She does indicate in such email that the police report was not an entirely accurate account of events. Since she has sent this email, I have met with her in my office. She does not, quote unquote, wish to pursue criminal sexual conduct charges. She's concerned about how they may affect their children going forward. Did not recant those, did not recant the unlawful imprisonment. The interfering with a crime report was added with police testimony at the preliminary examination, and the resisting and obstructing is obviously the police, not my victim.
Is obviously the police not my victim, is that what you said?
Correct.
Thank you.
She did, again, come in and meet with me. She indicated to me that she's very frightened of the defendant. She wishes to move forward and have him held accountable, although she wishes that that would be without the criminal sexual conduct charges. Again, she did not recant those. She did express to me multiple times in my meeting with her and in my email sense that she's frightened of the defendant and wishes for him to stay in custody.
If I may.
Just a moment. So if you don't have a, did she testify to the CSC at trial or at preliminary exam?
She did not. She was present, but somebody covered that examination for me. She did not testify. It was based on the police statements.
So if this goes to trial and she's not on board, you have police officer assaulting, resisting, and interfering with crime report. Those would be the two viable ones based on the preliminary exam transcript?
Based on the preliminary exam transcript alone, however, she did indicate to me that she would honor a subpoena and would show up and testify. She just wishes not to proceed on the criminal sexual conduct charges if at all possible.
Has there been any interference that you're aware of?
Since he has been in custody, I know that there have been a number of phone calls with his family. I have not personally reviewed them all. I have asked for a detective to review them to see if there's continuing interference.
You know, sir, here's what I have to say. Normally, CFC charges where they're punishable by life, I'm not letting you out. But if I don't have a victim, and I know she's scared, but all victims are scared of multiple things, when there's been a trauma. I don't know what happened here, but it looks like the viability is, on the people's case, if she chooses to not testify. On the life offenses, the primary offense may be the felony of 20 years, which is home invasion, and if she doesn't show up or changes her mind, it will simply be a 2-year police officer interfering with a crime report, which is a felony of 10 years. So I'm gonna give you a bond, but let me just say something to you.
Yes, Your Honor.
If you have any contact with her whatsoever, directly, indirectly, or otherwise, there's no contact in my world means you don't get creative. No messages through carrier pigeon, smoke signal, email, AI, third parties, Hallmark cards, flowers, anonymous, anything. You see her in a McDonald's, you just leave. I don't care if you pay for your food and didn't receive it yet, you just get out of the building and you go to a different McDonald's. You're at the same Myers, you go to a different one. You're not gonna see your kids because she's got custody of them right now. You're not gonna see them. We can talk about that later. I don't know if she's filing for divorce and maybe we can work it out with the family court judge, or maybe you're filing for divorce. I do not know what happened here.
No, it wasn't. Oh, yes, sir.
Sir, I don't know what happened here. But there'll be no contact. She simply doesn't exist in your world right now. If you violate, you're gonna be in that jumpsuit faster than you can say the word violate. Because I'm gonna have law enforcement give you an Uber ride to the hotel in Mason again and put you back in that jumpsuit until this is all resolved. Do you understand?
Yes, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I'm a DoorDash driver.
You have a valid driver's license?
Yes, Your Honor.
And on behalf of the people, this felony information needs to be amended. Under victim or complainant, it has Sabrina Maridi, I guess that would be his wife's name. But it also has Tyson Robert Thomas, unless that's a child's name.
They have a child of the same name as the defendant.
So are there any charges against that child?
He was a witness and did give the police a statement. There are no charges specific to the child, so I will remove him as a complainant.
He should then be under the witness, and it looks like he is, so he shouldn't be under victim.
I will get an amended file, Your Honor.
Thank you. Do we have, oh, we do have, that's October 2nd, okay. You have a place to live, sir?
Yes, Your Honor.
Where?
My grandmother's home, 58.
Just a minute.
Yes, sir. 23 Durwell Drive, Lansing, Michigan.
Spell Durwell.
Yes, Your Honor. Durwell Drive.
Lansing,
Yes, Your Honor.
48.
911.
And you're sure you can go there?
Absolutely, Your Honor.
So let me, so where does she live? She lives in the Tisdale?
Yes, Your Honor.
Okay, so how far away is Tisdale from Durwell?
About 4 miles.
Okay, so you're not going to be within 1,000 feet of her.
Yes, Your Honor.
So your DoorDash, don't be door dashing 1,000 feet, or you figure out your parameters there, because we're gonna have a GPS tether on you.
Absolutely.
And they do this crazy thing where one tire goes over for 1 minute and they wanna benchmark you. Now, I don't always entertain those, but figure it out, so we don't even have to waste my time looking at those. Because if you come within a distance of her where I think you're doing it to intimidate or harass or demean her, it's not accidental like those 1 minute tire drives that we keep having to respond to. I'm just putting you back in the jumpsuit. Have I been clear?
Understood, Your Honor.
Good, so get a map. I'm sure you probably know the city pretty well if you've been doing DoorDash.
Yes, Your Honor.
All right. I'm giving you $100,000 PR bond with a jail GPS teller. You will not be with the victim. It's gonna have victim notification, and you will not be.
When a judge grants bond on serious felony charges, they take a risk. They weigh the evidence, the victim's cooperation, the flight risk, and the danger to the community, and they make a call. In this case, the judge made a calculated one. Tyson Thomas was facing serious charges including unlawful imprisonment and criminal sexual conduct. His alleged victim had sent an email to the prosecutor suggesting the police report may not have been entirely accurate, but she also told the prosecutor she was frightened of the defendant and wanted him held accountable, just not on the most serious charges. She said she would honor a subpoena. She said she would show up. She just didn't want to push on the CSC counts. The judge heard all of that. She acknowledged the viability problem. She reduced bond from $200,000 cash to $100,000 personal recognizance with a GPS tether. And then she delivered what might be the most memorable no-contact warning in this entire transcript. No McDonald's within range of the victim. No shared my gear. No carrier pigeons. No Hallmark cards. No flowers. No AI-generated messages. No smoke signals. No anonymous anything. She told him because he works as a DoorDash driver to get a map, learn his delivery radius, and stay 1,000 feet away from where his victim lives, because the GPS tether doesn't forgive one tire going over the line if the intent is clear. She told him he could be a free man who works and gets through this, or a jailed man. She said the choice was entirely his. She was not funny. She did not play jokes, and she meant every word. This is what a judge sounds like when they're genuinely trying to keep someone out of jail while making unmistakably clear what happens if they fail. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns because justice never gets old.